All right. Good afternoon, everyone, and thank you all for joining us today. We are very excited to present 8 planning steps for the second half of life. Please feel free to ask any questions you may have in the chat box at any time, and we will go ahead and address those questions at the very end of the presentation. I'd like to go ahead and begin just by introducing you to our team. We have our 3 attorneys, Randy Clinkscales, Jenny Walters, and Adam Dees. Jenny and Adam are both with us here today. So yeah, here's a picture of our team here. And on the next slide, you'll see some of Jenny's accreditations. Jenny is a partner of Clinkscales, and we are very lucky to have her here as one of our attorneys. And then we have a next slide with some more of her accreditations here. We published author, very exciting, in a newsletter. And then next we have Adam's information here. We're very excited to have Adam as part of our team as well. And then we have another slide with his accreditations. And like I mentioned, please feel free. I know we have a few more joining on now a little bit later. So like I mentioned earlier, please feel free to ask any questions you may have in the chat box on Zoom. And if you have any trouble with that, please let us know and we'll help you get your questions answered. And then I'm going to go ahead and hand it over to Adam and Jenny to start our 8 planning steps presentation.
Thanks, Emily. I don't know if Emily introduced herself, but that's Emily Norberg. She is our client outreach coordinator and was the one that wanted to put together this topic and this discussion. And we think that it's pretty timely given what we're all experiencing. We'll kind of talk about that here in a minute. But really, our law firm asks about 3 questions of all of our clients. First is, what happens if you die? What happens if you get sick? And then even more concerning is what happens if you would need nursing home care, if you would get dementia, Parkinson's, or Huntington's, or one of those other diseases. And I know that in talking with families who are going through and really talking about these questions, there's 2 parts to that. There's really long-term planning, and that's talking about what living your best life looks like as we all continue to age. And then starting to think about what life would look like if we were in a crisis, if someone did die, if someone became sick, or if someone started to get dementia or Alzheimer's, and started putting the support structures in place to address that crisis before we would actually get there. And right now, obviously, the crisis that is going on is the coronavirus. And so just to kind of give you an overview of where we were at, all this information is from the Center for Disease Control as of last week. They released new information on Thursday mornings. As of last week, there are about 3,952,000 confirmed cases. Of those cases, 55% are in people ages 40 and older. Ages 40 to 65 make up 38% of U.S. cases. And then cases for people over the age of 75, 9% of those. So 70% of all the cases for people above age 40 are people aged 40 to 65. And so that just is very concerning, because a lot of the people who are caregivers are in that age 40 to 65 age range. And many of the folks that they are taking care of are in that over the age 75 range. So in the United States, the then scary part is that 98% of the deaths from the coronavirus are in people over the age of 40. And 33% of the U.S. deaths are over age 85. But really, the other piece of that is people between the ages of 65 and 85. 50% of U.S. deaths from the coronavirus are people in that age group. And so when we realize that that's kind of what we're facing, we start to think about, what does your family need, or what would my family need if we do go into a crisis? And the 2 things they really need are information about your health, about your health care, about your resources, and then options to help get through that crisis and to put those options to make sure that all the options are available and we can use all of the tools. And so what we're going to talk about today is a lot of information that you can have, that you can pass on to your family and your friends, information about yourself, information about legal options, information about care options, and then second, talking about how we access those options and put the legal framework in place for you and your loved ones to have options if we do end up in a crisis like we're in right now. So, but the first part I'm going to turn over to Jenny, and that's the first step in that is really having good foundational documents. And Jenny, what are good foundational documents, and how do those foundational documents give your family information, but also options as we go through aging or we go through those processes?
So the foundational documents are number one, because really these are the most important. They're kind of open the doors to the rest of the planning we're going to talk about. So in our office, those foundational documents are going to consist of powers of attorney, which we're going to break down into separate financial and healthcare powers of attorney, a living will that goes hand in hand with the healthcare power of attorney, and then we're going to get into a little bit wills and trusts, irrevocable trust, and special needs trust, and each of those options just takes the planning to another level. And so before we go to the next slide a second, Adam, I want just people to think about, sorry, of those documents, what might be the most important to have? And I'm going to give you our opinion on that. So, okay, go ahead. Okay, if you answered power of attorney, we would agree with you. So a power of attorney just generally is a legal document where one person who's the principal authorizes another person who is the agent to act on his or her behalf. Now, there's some misconceptions, and I'm going to explain this in more detail, but just having a power of attorney doesn't mean that you're covered or that your agent can just do everything they need to do. If you just have a power of attorney, it gets a lot more detailed than that. And so I want to talk about the two broad types of powers of attorney, and then we're going to get into the details of each one of those. And Adam and I were talking before this, when we were preparing for this, that we could probably talk for an hour about powers of attorney alone, but I'm going to give you the highlights, and I think you'll be able to see why this could be such a detailed topic. So the first type is the financial power of attorney. You may also see this mentioned as the durable power of attorney. And the financial power of attorney authorizes your agent to basically deal with your finances, your property, your stuff. Basic examples would be like opening and closing bank accounts, selling property, acting for you if you need to defend yourself in litigation, and basically acting in your place. Now, again, just because you have this document does not mean that person can act in your place in every situation. It needs to be in the document, which we're going to get to. And so there is some optional language in the power of attorney that has to be in there, and you'll see it's excluded if it's not specifically included. And some of the major examples that are really important to our office is transferring the homestead. There is, in Kansas law, if you are married and you have a home, even if you have authorized your agent to deal with your real estate, they can't transfer your homestead unless it's specifically described in your power of attorney and your spouse has signed off on that power of attorney. And that's really important to us because, as we'll talk about later, if we're getting into long-term planning or Medicaid planning, there are some really important reasons we would need to transfer that house around. And if it's not in that document, it causes some problems. Another big one for us is gifting. And sometimes I see powers of attorney that have gifting, but it limits the person to the IRS exclusion, like that $14,000 limit, which might be fine. But again, when we get into more advanced planning, get into long-term care planning, that can limit our ability to protect assets and do the planning that we need to do. So even if it has gifting, it gets a little more specific than that. Another big one for us is the trust. You have to have specific language in there if you want your agent to be able to set up a trust for you. And we're going to talk about some different types of trusts. And so it's really important to have that language in there so that if a trust is a good opportunity or a good tool for your estate plan to use, then your agent can set that up for you. Another big one that's not on the list, but again, there's about 14 of them, and Adam's going to get into this, is beneficiary designations. If your power of attorney doesn't specifically let your agent change your beneficiaries, then that can limit some of the planning, again, if you get into the long-term care planning. I know some of these powers we want to be careful. We can give people a lot of power in these documents, and we want to be very comfortable with those powers. We want to be comfortable with the agents, but that's a conversation that we would have about what powers we're giving that agent and why they're important as you go through different steps of life. And when we're talking about these 8 steps, this is when these powers get really important.
And so, Jenny, where have you seen people kind of stub their toes on not having this language, or having part of it but not all of it? I mean, what happens if we don't have those powers in a power, or what can happen if we don't have those that language?
So on the homestead one, try to give a simple example, if we have, let's say, I'm going to joke, I always put the husband in the nursing home. Let's say we have a married couple, the husband's in the nursing home, the house is most always owned jointly. If we're doing Medicaid planning, it's really important to us that we transfer the ownership of that house to the wife. One of those reasons is that if estate recovery wants to put a lien on the house, it makes it a little more difficult for them if we don't have that Medicaid recipient on the house. Another big reason is that if after the husband is qualified for Medicaid, let's say the wife wants to move, wants to downsize, just wants to sell the house, if we've gotten that house transferred to the wife prior to qualification, the wife can sell that house and keep the money. Whereas if the house is stuck in husband's name because we couldn't get it transferred, she's going to have to split the assets with that husband, and then we're going to have to deal with a spin down to keep him on Medicaid. On the beneficiary side, let's use that same example. Husband's in the nursing home and wife has him as the beneficiary of all her accounts or on property. That doesn't make sense if somebody's in long-term care, so we'd want to go in and change that. And if we don't have that ability, wife's going to go into the bank or talk to the insurance company, and they're going to say, I'm sorry, that language isn't in there. You can't do that. Or even if we have both parents that are incapacitated and the kids are trying to do this. And so institutions are getting very picky and are going to want to see that specific language in that document to be able to make the changes that we're suggesting get made.
And so now is the time to do that rather than wait until trying to put these things in place rather than when we get into a crisis. Is that what I'm hearing?
Yeah, and then we're crossing our fingers that somebody's got capacity to get that updated and scrambling a little bit.
So what other kind of powers of attorneys are out there?
So the other type, again, we separate this. Sometimes I see powers of attorney that are all combined into one, but we separate ours into 2 types or 2 documents. The second is going to be the healthcare power of attorney. This is it's kind of self-explanatory, going to deal with all of your healthcare decisions, consenting to surgery, admission. We get into some, you can make this, just like the financial power of attorney, you can really make this personalized. And so if you want language in there about the types of care you want, if you don't have capacity or not wanting certain drugs, if you're in long-term care, we can add in those details. But the big picture is that you want somebody named that the hospital can talk to that can make healthcare decisions for you in the situation. It really just comes into play when you can't speak for yourself. You can't act for yourself.
So Jenny, kind of piggybacking on this, what are some good things to think about when you're choosing who you would want to be your financial power of attorney or your medical power of attorney?
That's because I know of at least two people who have named different, usually it's a kid, it's your spouse and then your kid, have named different kids on different documents depending on what they think those kids' strengths are, the person you're most comfortable with, making decisions for you, and also on the back end, if it's a kid, the one that's going to be most comfortable doing that for you. So it's important to have those conversations when you're setting these up to know, again, who you're going to want, but also who's going to be okay with that burden on the other end. You can name more than one kid. I say kids because this is usually the example. Usually it's the spouse, and then we have children as the backup. If the spouse doesn't have capacity, we go straight to the kids. You can name one. You can name more than one if you want them to act all together. And so those are the types of questions that we go through before we put that person's name on the document, giving them that power. So hand in hand with this financial power of attorney is the living will. And the living will is also known as a healthcare directive. That's where you're going to list the decisions you want made for you. If you have a terminal condition, substantial brain damage, basically have a condition you're not going to recover from, that living will is very specific. Basically, if two physicians say that you have something incurable, something you're going to pass away from, regardless of what is done for you, you want to be made comfortable. We can be very specific. You don't want respirator, ventilator, tube feeding, all of that stuff. And again, you can make this very personal to you, but this is the document that gives direction to your healthcare power of attorney agent about what you want done for yourself in that situation. So again, it just goes hand in hand with that healthcare power of attorney to hopefully avoid a situation where either your agent doesn't know what you want, or there's a disagreement between what you may want and what the hospital wants to do for you. This makes it clear.
Yeah, and I think some things that I've talked with some folks about recently is, with the COVID-19 virus, respirators and ventilators are really one of the main treatment options. And so we've had people take a look at their powers of attorney and say, if I'm diagnosed with COVID-19, go ahead and put me on a respirator. Go ahead and put me on a ventilator if that's the diagnosis. If it's other diagnosis, then we don't want to have that provided to me. But because we know that's how we treat that specific virus, that's something that I've had several conversations with people about. And that's the other nice thing is, as situations change, these documents are changeable, and we can go back and really make them specific for you. Are those conversations you're having with people too, Jenny?
Yeah, and the only other thing I wanted to mention is that in that conversation, this is different than a DNR, which is something you do at the hospital with your healthcare provider. A do not resuscitate is different than this living will that gives your family and your agent direction. So absolutely, that's
what. So I know we don't have a slide on it, but what is a DNR?
So the DNR, the do not resuscitate, the simplest way I think about it is that you got the living will that basically says, this is what I want to happen if I'm dying. I don't want these procedures. I want to be let go. Whereas a DNR is going to be at the hospital, if they come find you at your home, you don't want to be brought back. If basically just want to be left alone if you've passed away. You don't want to be resuscitated back.
So if your heart stops,
right,
you don't want to be brought back.
Yep.
All right.
Okay, so we've hit on some of these as we go, and I think this might be a little obvious by now, but why do you need this power of attorney? We've talked about all the powers we want in there, some situations. But basically the big picture is that a lot of people think that, well, my spouse or my children are automatically going to be able to do things for me. That might be true on the healthcare side. I think you can get away with that a little more, as far as if you don't have a power of attorney, the hospital's probably going to listen to what the spouse says as far as what needs to happen. But definitely not on a financial power of attorney. You're not going to get anything done unless you have that document. You may have a small town bank that may work with you, but that's becoming very rare. And so if you don't have this document and you're trying to get some of the things done that we've talked about, you have to go to court and become a conservator or a guardian. And that takes time. And if you're in long-term care, time is money. Long-term care is approaching $7,000 a month. Let's say it takes 3 months. That's about $20,000 that's gotten blown through as we wait. In addition to the attorney's fees and the headache to just go through the process of getting that in place. I'll tell you, we don't like doing them. And so just having that power of attorney in place just eliminates all of that headache. It's done. Even if you name an agent and your agent isn't able to act for some reason, we even have in our documents that that agent can name someone else. So we basically do everything we can to avoid the situation of having that guardianship and conservatorship and the headache that goes along with it.
Right. And if we do have guardianship conservatorship, then the court gets to oversee everything, right?
Yeah, then you got to do an accounting every year. And yeah, just all things to avoid.
What are some other foundational documents we need, Jenny?
So just briefly, again, I feel like we're kind of going, biggest priority on down. I don't want to minimize anything because they're all really important. But we've talked about how to make decisions for people, but now I want to hit on just dealing with your property. And minimum have a will that explains how your property should be distributed upon your death, who you want in charge of that. And if you have minor children, this is where you're going to want to name who should be the guardians of them. If you want to take it another step, in certain situations, a trust is more appropriate. And we've got a slide here that's going to compare them side to side. There's a lot of types of trusts. You can make them irrevocable or revocable. It's similar to your will in that it's a document that names what you want to happen to your property. But as a will is going to kick in when you pass away, whereas a trust can also take care of your assets if you just lose capacity and need somebody to be in charge of that. Sometimes a trust and a power of attorney can kind of overlap. But again, the trust only deals with if you die, what happens to your property, where a trust can take care of, well, what happens if I live and I'm in long-term care or in that kind of thing. And it's pretty clear on this slide, a trust, one of the big reasons we use them as a tool is because they avoid probate, whereas a will, and this is a kind of a misconception, if you have a will and you want the property to pass according to your will, it means you're going to probate, you're paying extra attorney's fees and extra headache. It's one of those things we like to avoid unless it's necessary. There's a few situations where it's a good thing. A living trust stays private, whereas a will gets filed, it's public. With your living trust, you do need to fund your trust and get your assets in there correctly. And with your will, you don't have to do that. But you do need to check that if you want things to go through your will, if you have a joint asset or an asset with a beneficiary, it's going to completely bypass your will. Again, a living trust prepares for your incapacity and dealing with your assets, whereas a will doesn't have anything to do with your incapacity. It only has to do with your death. And again, you have to name that guardian or conservator for your minor kids in your will.
So what happens if I don't have a will or a trust, Jenny?
That is a great point. Some people think that that means the assets are just going to go to your spouse. Basically, if you have beneficiaries or if you have a joint owner, it's going to them. There are some situations people get caught that maybe they have real estate in their name. If assets have to go through probate and you don't have a will, they're going to go through the laws of intestate succession, basically means without a will. You may end up with half your property going to a spouse and half of it getting sent to your kids. Or, basically it's out of your control. It just goes according to the law. So to wrap up, That was a lot of information, but the big picture is you can either plan ahead and choose who's going to make these decisions for you and what kind of decisions are going to be made, or make the choice to not do anything and let the court or someone else out of your control make those decisions for you. And with that, Adam, tell us about the second step.
So when Jenny and I talk to people about this, we always end up spending the most time on probably step number one, because it's so important. Because without those foundational documents, pretty much everything else we are going to talk about here about protecting assets from the cost of long-term care to, choosing appropriate and finding good care for you. Many times those things can't happen, or at least there can be some stumbling blocks if we don't have that first piece in place. And as we know, right now, the average cost of a nursing home in Kansas is about $7,000 a month. Out here in Hayes and Western Kansas, it can be a little less, $6,200 to $6,400 a month. In Wichita and some of those areas, I've seen bills of $12,000 a month. And so, without those documents in place, it just makes paying for long-term care that much harder. One way you can pay for long-term care is out of your own pocket. You can sell assets or a business if you'd like to. A lot of folks don't want to do that, and that should never become necessary. One of the myths that we hear is that if you need long-term care, that means you have to sell your farm or you sell your business. And if you take one thing away from this, please know that that's not true. Some people choose long-term care insurance or other private medical insurance. Medicare can pay, Medicaid can pay, and sometimes even there's veteran benefits available for veterans. So how do we plan for this, and why plan for this? The process of planning is probably long-term care. The statistics I've seen is that 1 out of 3 people are going to end up with Alzheimer's or dementia. And that means that, out of me, Jenny, or Emily, who are part of the presentation today, one of the 3 of us is going to potentially end up with Alzheimer's or dementia, and Emily and Jenny will probably tell you it's going to be me. Which means that one of them is probably going to be a caretaker. So 2 out of 3 people that we're meeting with today, or that we meet in our office, are going to be impacted by that. And so doing this long-term planning is really about protecting yourself and protecting your spouse and your children to work through that process. So again, different payment sources: retirement funds, paying privately, long-term care insurance, Medicare, Medicaid, and we're just going to kind of go through each one of these a little bit. Long-term care insurance, there's really 2 types out there. There's a typical, which is you pay for it, and if you do need long-term care or skilled nursing home, then it will pay out during that time frame, and if you don't, you just lose it. But they're coming up. They've created a hybrid plans now, where you can pay for a long-term care insurance that have premium return riders. So whatever dollars you paid in, if it doesn't pay out for care for you, then that goes to your spouse or your children. Or they can have a life insurance benefit, so that let's say you have $250,000 of long-term care insurance, and it's going to pay that. But if it does not pay for your care that amount, it will pay to your family that amount. So Medicare does cover a little bit of long-term care if necessary. If you're in a hospital, it will cover that. If you're in skilled care, it will cover up to about 100 days, as long as you are maintaining or improving your status. And so a lot of times we'll see that people, who do go to the hospital and then are released to a skilled nursing facility, continue improving till, they decide that at about day 80 or 90, we've gotten to where that person can get to. And so, Medicare has said, okay, we're not going to pay anymore. So then we have to look at another source. Medicare does pay for hospice, does do some in-home care, but there are some rules. Medicaid is also a potential payer source that will pay for nursing home care. There's an aging waiver program or home and community-based services that it can help pay for services to come in. It doesn't pay for a personal care home that doesn't accept Medicaid. It doesn't pay for assisted living facilities or independent living facilities, and it doesn't pay for a lot of in-home care. It can pay for some through the home and community-based services, but there are some waiting lists that we're waiting on, that we have people waiting on. There's also, when we look at Medicaid, a 5-year look-back period. So if someone has made gifts over $50 in any month, then they become ineligible for a period of 1 month for every 60. I think it's up to $6,800 now, isn't it, Jenny?
I think they did. I know it's at least 63. I think they bumped it up again.
So $6,800 a month for every amount of that given away, Medicaid's not going to pay. So we have a lot of our folks that say, hey, can I just add my children's names to my assets to protect them? And we're just going to give them our resources. And that, that's something you can do. But what that does is that potentially subjects those resources to things that can happen in their life. So divorce, they end up with student debt, they become disabled, or even if they decease. So I had a client when I first started practicing law, one of my nicest clients. She had co-signed a student loan for her nephew. He was going to go to the military and pay it back. He was going to get a great job and pay it back. And lo and behold, he dropped out of the military, dropped out of school, and he couldn't pay it back. So they came to her and said, what resources do you have? And she looked at me and she said, well, I don't have any resources except my mom put my name on her CD, which was all of the savings that she had. And I said, well, that's now in your name. And that can now, now mom's CD is subject to those student loan creditors. So we got to figure out a way to pay this back, or they're going to go after your mom's retirement. Everything was was above board, and life just happened. And so, I always caution people to be very, very careful. In fact, I have to caution my mother. I say, Mom, don't put my name on your bank accounts. That's a risk. Does she still do it? Yeah. Every year at Christmas, do I ask her what she did? And she said, well, this is what I did. And I said, well, let's get this fixed. And we do, and life goes on. So instead of giving your children resources, some of our clients want to do put together irrevocable trusts. And we, talk to them about putting those together to protect the most important thing that they have, whether that's a business or a family legacy. As long as we put it in there and wait 5 years before applying for Medicaid at this point, those resources will be protected. It'll be protected from other creditors. You can still change your beneficiaries. It's not set in stone, and you can still exert some control over that. So just because someone says, hey, you need to set up an irrevocable trust, like powers of attorneys, not all irrevocable trusts are the same, or they created the same. We like to have these types of provisions in there to allow for you to continue having control. And so those are the ways that we kind of look to plan during folks' lifetimes. How else can we plan to minimize so that your children aren't having to pay for your long-term care?
Yeah,
and to protect those resources.
Mm-hmm. So there's some tools that come into play. We talked about gifting, protecting assets that can happen, while you're alive. If you're looking at long-term care, there's also some tools to protect from liabilities that of after your death of your kids. You kind of talked about those 4 Ds. So within your trust or your will, you can set up a trust for the next generation, for the next person. If you have somebody that you feel like you need to protect or need to protect that inheritance from some situation. The Irrevocable Trust is a great tool for protecting assets from long-term care, given that 5-year look back. And again, we're very careful about the powers and having that very specific to be able to protect property from Medicaid specifically or any other creditor. And then we'll get into more detail in a minute, special needs trusts and protecting resources for those types of beneficiaries. So we've got the basic, gifting and irrevocable trust in 5 years, but then there's a lot of steps after that that you can really get into detail and really set things up to protect them as much as you can. And so, Adam, we talked about powers of attorney and beneficiary designations, and well, what if I just name my kids on my bank accounts? But a lot of times, okay, let's say your mom didn't put you on your bank account, but what if she made you the beneficiary? Isn't that okay?
Well, that can be okay. I don't know. That would probably be okay with me. I don't know if it'd be okay with my brother. I have a brother. He lives in California. And I would encourage my folks to put both of us maybe as beneficiaries on that account. But if I want to, add protections, or if my parents wanted to add protections into that through those trusts that Jenny was talking about, through supplemental needs trusts or an irrevocable trust, then having, me and my brother be the beneficiaries designated on that account, may not be what my parents want. I know that a lot of our clients also do charitable giving, and having all of that flow through the same plan. And not every, as we're going to learn here, not every resource that people have is the same and is equal. So Jenny pointed out that the homestead and that your home is kind of a special resource that you have, and it's special under Kansas law. And so there's some really specific things that we want to do and we want to have for that. And the other piece of that is that, we should update them now here before we get to a crisis, because I just love this slide, because we don't know what's going to be open and when. And at this point, we don't know how they're going to be open. We may all be open virtually. We may all be open in person. And so doing it now when we're not facing an imminent crisis, I think is really important, and can set up your family for success. One of the things we're very cautious about is not naming your estate as a beneficiary, because if you do that, that prompts probate. As soon as you say, hey, I want my estate to be my beneficiary, then we're looking at a probate process. The other piece of that is that we want to look at this as retirement planning. So, my family, my dad's still living, and so I would hope that my mom, she's put his name on all of those bank accounts, because they've created a life together, and want to protect both of them. And so really, when we look at retirement planning, we're looking at not only making sure that we can pay for long-term care, but then what happens and what's the best way to pass any resources that would be left after our death. And one of the very special resources is IRAs, 401ks, 403b plans, 457 plans, all of these what we call qualified retirement accounts or qualified assets. They're great because if you have them, you know that you have not paid taxes on them yet. In fact, you may have gotten a deduction on your tax return for doing that. But when you pull those resources out, then you are taxed on them. And in fact, IRAs, you can't have them, owned by a trust unless it's a very, very specific type of trust, and it's done very carefully during your lifetime. And your financial advisor is going to work with you to grow those resources. Our job then is to look at, okay, how do we protect those resources for you, and also to pass on to your children. And that's where having appropriate beneficiary designations is really important, and layering those designations. So we've got our beneficiary designation. Your primary, you're probably going to want that to be your spouse. Your contingent, you may want that to be your children. You may want that to be a trust. A third beneficiary may be a trust, maybe a charity. It really depends on your specific situation. But the other piece of that is, if you don't have beneficiaries, then guess what? Then we are looking at going down to a probate, and working, at the courthouse to do those types of things. The other piece of that is Congress in the end of 2019 implemented some new rules regarding IRAs and beneficiary designations. So there's a new stretch out. So it used to be, before the Secure Act, it's called the Secure Act of 2019, if you had an IRA that you hadn't been taxed on, and you made your children the beneficiary of that IRA upon your death, your children would have to start pulling those resources out, but they would have their entire lifetime to do that. So if your children were in their 50s or even early 60s, they could have 30 to 40 years to pull those resources out and push that tax burden as far down the road as possible. But under the Secure Act, now all the IRAs and 401ks have to be paid out to just normal, everyday beneficiaries within 10 years. And Congress is expecting an extra $15.7 billion in revenue over the next 10 years just by this little change in the room. And so now, if you name your spouse, this 10-year rule doesn't apply. But if you name your children, it does. And yet there are some other super beneficiaries that I like to call, that aren't a part of this 10-year rule, and we can actually, by setting it up correctly in a trust, take advantage of that person's lifetime. So again, a minor child, they can, they'll have to start pulling out those IRAs and being taxed on that when they receive it, but the 10 years doesn't start until they turn age 18. If someone's disabled, we can use their lifetime rather than that 10-year rule, or someone who's chronically ill. And then this is kind of an interesting one, but if you set a beneficiary up, if someone that's not less than 10 years younger than you, then that person will use their lifetime as well. And so the conversation has changed from, okay, do you want to leave the IRA to your children and try to stretch that to, maybe there's children that are in different situations. So for example, I live here in Kansas. My brother lives in California. I can tell you the tax structure, the personal income tax structure in California is much higher than it is here in Kansas. And so from a state tax level, it would be much better, for state taxes to be paid in Kansas than it would in California. And so now, again, you name a trust as a beneficiary, but that 10-year rule is going to apply. And so we can, within that trust say, hey, maybe we want a beneficiary who is one of those super beneficiaries, somebody who's disabled, to receive IRAs as opposed to some other things. Or you can give your beneficiaries some control about who receives taxable funds, non-taxable funds, and work on that. And so everybody is a little bit different. There are two types of trusts that deal with this. One is a conduit trust. It says, hey, every year that we get those required minimum distributions out of IRAs, we're just going to pay that through to the beneficiaries. That's really not a good idea anymore under the Secure Act, because it really doesn't help. It just says, hey, we're going to pay it out over 10 year. Whereas an accumulation trust, which is one that, the required minimum distributions get paid to the trust, it can hold it. There's some tax issues with that because trust rates are higher. It can provide protection against divorce, death, disability, debt, those types of things. But we can also take into consideration that 10-year rule. We can look at those super beneficiaries. We can try to move some of those things around and do some post-death tax planning. But at the end of the day, we need to make sure that we have multiple beneficiaries. So for example, if we have a spouse in a nursing home, as Jenny was talking, We would probably want the primary beneficiary to be some type of trust that would marshal those resources. The contingent beneficiary could be the spouse, and then maybe the third would be a children or another type of trust, depending on the children's situation. So, the Secure Act has created some opportunities for folks, and yet this is one of the areas where I think some additional planning and really looking at what your resources are, how, whether they're qualified funds, non-qualified funds, if they're IRAs, and sitting down with a professional to talk about that is really important. And so this is one of my favorite topics, is special needs planning, but Jenny's going to take over on, we talked about these special needs people being super beneficiaries under the Secure Act, having some benefits with the IRAs. Jenny, what are some other things that we can do with supplemental or special needs trusts to provide quality of life for folks?
So these types of people, we're very specific when we initially talk to people over the phone to see if, what we can do for them. If these types of people are in their lives, because there's some very specific and special things we can do for them in different situations. And so just generally, this is going to be planning for a minor child that has a special need, or an adult that's under 65, and I'll explain why that 65 makes a difference, who has a special need that was either present at birth or acquired through illness or injury, disability. Or it might apply to just a kid who maybe can't manage finances, maybe isn't officially disabled. There's a lot of different categories there. And so when we have this type of person, we're probably going to talk about setting up a trust for them, because as Adam talked about with beneficiary designations, it doesn't make sense just to list someone like this as just a pay on death beneficiary on a bank account or on property, because it's really, there's some things we can do to protect resources for them. It just doesn't make sense to dump property in their lap if they're disabled or on government benefits. And so generally, we're going to talk about a third-party trust. This is basically a trust that, a parent would maybe set up for a child when they die, or if you have a grandchild you're wanting to set aside money for in a separate trust. Or the other types of trusts, the first-party trust or the pooled trust is going to be a trust that individual is going to set up for themselves. And so if I was disabled or on benefits and I had some money, I could either set up this D4A trust where I put my money into a separate special type of trust, or I use this pooled trust. They're really very similar, but a pooled trust, at least here in Kansas, we use a lot. There's a company called Care, and they pool money together from these individuals and they manage it for them. And so you don't have to have an attorney or have complicated planning. You can go to these people and they can help you set up the trust, and they'll pull the money and they'll manage it. It's really a great program if we don't have a lot of resources we're dealing with, but to that individual, it's a lot of resources we can protect for them. And I mentioned that 65-year, and I don't think the reason that's kind of a magic age is because for these, the D4A, the D4C trust, you can do that when you're under 65. And so it's really important that if we've got somebody who's got a disability, that we kind of keep track of them, because once they get over 65, they're going to hit those just flat Medicaid rules and are going to have to spend down their assets to $2,000, whereas prior to 65, we can throw that money into either that D4A or D4C trust, and they don't have to spend it down to get on Medicaid. That money can be used to supplement their care and not just have to be spent on the nursing home. And so it's a really, really important tool that we use. We might have somebody who's disabled that we go ahead and set that trust up when they're 63, 64. We just kind of watch how they're doing. And when we're ready to transfer resources, maybe they need long-term care, we go ahead and fund it. The only catch that I want to mention to those trusts is that On the back end, Medicaid has to be paid back. If you're using your own money, setting it aside in this trust, Medicaid does have to be paid back from any money after you pass away that's remaining in that trust. But really, it's worth it. It's a great tool. The other piece of that I mentioned is when we're doing these trusts, is that if you have somebody that is disabled, instead of having their share sent to them outright, you could set up a special needs trust where their share is protected for them. And actually in our documents, we have that as a catch-all. We have it in every document that if any beneficiary ends up disabled, is a quote supplemental special needs person in the document, their share is going to be protected for them in whenever that situation comes up. What do we got next? I think next is back to you and what's one of your favorite topics. I'll let you take care of that.
So I'm a geek. I like the Internal Revenue Code. Well, I don't like it, but I find it fascinating because it's, in my opinion, or at least the way the Congress is using it is to socially engineer different things. But I don't know if you guys remember back January 1st of 2013, we were getting ready for a shutdown and there was going to be a fiscal cliff. And fortunately that didn't happen. Now we have, come through a bunch of several different arguments over the debt ceiling and, estate taxes may be going up here in 2024. And so really the big thing on the tax front is we just got to know what the situation is so that we can respond accordingly. So there are several different types of taxes. There's the estate tax, the gift tax, income tax, healthcare surtax. In Kansas, we don't have an inheritance tax yet. I don't see that that's going to happen in the Kansas legislature anytime soon. But as we have all seen, crazier things have happened. So right now for the federal estate tax, the 2019 exclusion was $11.4 million. The 2020 exclusion is $11.58 million. What that means is that if it only applies if an individual has over $11.58 million resources, or a couple has over $22.2 million at the end of their lives. Now that jumps down to $5 million indexed to inflation after 2025. Having said that, we still need to worry about capital gains taxes, and capital gains taxes are pretty simple. They're just what you pay if you're going to go sell something, and making sure we still get a step up in basis upon someone's death. The other real big one is the healthcare surtax, which is 3.8% of net investments. So that's interest, dividends, annuities, royalties, capital gains. This was to help fund the Affordable Care Act, or Obamacare. There are certain thresholds for it. A single taxpayer, $200,000. Married taxpayers, $250,000. If you notice there at the bottom, estates and trusts, the threshold for that to kick in is $12,500. So one of the things we know is we're talking about like supplemental needs trusts or irrevocable trusts. We need to work with with the trustee to make sure that we don't run up against some of those limits in order to pay those sure taxes. And to be really honest with you, I've only heard of one time, if you've got good solid advisors, and if we're working on things, that $12,500 limit was reached, and basically there was an accountant that fell asleep at the wheel of that. And so those are the ways, the legal documents that we work to put in place to really kind of come back to the beginning. And that's, if you develop a chronic illness, or if we do get into that crisis, why do we do all this? And so, Jenny, do you want to kind of close us with, so what options do we end up having if we have a chronic illness?
Yeah, and exactly. You get everything in place. I think the last step is to just know what the options are if something happens and you need these documents. So the first option, and the one that probably everybody wants, nobody wants to go to the nursing home, nobody wants to move, is in-home care. And we're going to look at ways to pay for that, including Medicare, which is going to be a little limited. Medicaid, you talked about home and community-based services and paying for care in the home. I wish it was as easy as that sounded. If you're in the western part of Kansas, unfortunately, just finding that sort of care is a little difficult, but it is an option if we can find it. Or long-term care insurance. If your long-term care insurance provides for in-home care, which it's got to be specifically in there, that's a whole other topic. Of course, you can private pay if you have it. If you've got the money and you can find the caregivers, you can stay at home. And unfortunately, that's pretty rare to have all of those fall into place. And you can pay private caregivers. Usually a better option is to go through an agency that specializes in that. Again, Medicare can pay for some of this. It's a little limited. For homebound, you may need to have skilled or rehab that's approved by a physician. It's basically not going to last forever. Some other options to help support, staying at home is having somebody live with you. That could be your spouse as a caregiver or a kid, and having some tools in place to make you as successful at home as possible, like a medical alert that might alert somebody if you've fallen. They've gotten really advanced in the types of alerts and the types of monitoring systems you can have at home. It's not just limited to just having a push button. It's really pretty cool what they've done. And then finally, if you do have to move, then some options might be an adult daycare center, which can be really important to provide some breaks if a spouse is a caregiver or a child is a full-time caregiver. Just having somewhere to take that person that needs care so you can have a break. And it's not necessarily just jumping to the nursing home as the next step. There's some steps in between if you have things in place to pay for it. Assisted living, there's some continuing care retirement communities that you might go in as the lowest level of care and then get to stay there all the way through instead of bouncing from place to place. Skilled nursing facilities, which we're most familiar with as just regular nursing home. And if you need hospice services, those types of places can provide that. So we've kind of we've got this broken down to 8 steps, giving you a lot of information. So what is the next step? What do you do with all this? And so what we'd like to do is, I'm hoping we can make this as easy as possible. If you were in person, we'd have some really good snacks, and we'd have a worksheet for you to fill out, in person that you could just hand in. I appreciate that the Zoom and the webinars have, you don't have to travel. We can reach people farther. You can do it probably from a more comfortable chair, but again, you're missing the really great snacks. But we'd like to offer you, just for signing up for this, if you fill out our survey, we'll send you one of our books. And Emily is going to actually share the link in the chat box. We use this Survey Monkey, was a really neat tool that you can just click on that link, fill out the survey, and again, we'll send you that free book. And then probably the most important piece of that is at the bottom is just let us know if you'd like us to give you a call. Our initial consultation is free. You're going to talk to probably Tracy in our office. Is going to just talk to you about your situation and feel out if we can help you and schedule that appointment. And again, that first consultation is free. So if you're able and if you want to get this done quickly, click on that link. If you have any trouble with it, let us know. Emily's also going to follow up with an email after this. So I might just give everybody just a couple minutes to work through that with those few quick questions. And if you have any other questions, you can put them in the chat box. I think we have one that we'll get to, and I think Emily just appeared. So.
Yes, so you are now all able to unmute yourselves. I had muted everyone earlier, but now you can unmute yourself if you have a question or if you can't figure out the chat box or anything like that. We do have one question, and I think we'd like to address it right now while you all are clicking on that survey link. Feel free to ask us questions like Jenny mentioned if you're not able to access it or anything like that. It looks like we have a question here, Jenny and Adam, that says, if a property is set up as TOD, which I'm assuming means transfer on death, to 3 different people and one dies, does their share transfer to their beneficiaries, or does it just transfer on death to the 2 living individuals?
Adam, you want to take it? I know this is a great question. This is a great example.
It doesn't matter, but Jenny is right. That is a great question. I think that highlights a couple of things. One is one is the lack or the inability of a transfer on death deed to plan for that situation. And so it really depends on what the deed says. That's where, we talked about the IRAs and having multiple beneficiaries so that if one dies, we know who that backup is. And that's where I think it's having a trust can be very helpful, because you can say, so instead of having a transfer on death deed, the trust would say, upon my death, it's going to go to these 3 people, but if one of them dies, then it's going to go to, their children. Well, a lot of the families we work with, the children of the person that was supposed to receive the property, they may be under the age of 18, they may be under the age of 25. I remember what I was like when I was under the age of 25, and we may not want that person to, have access to that resource, right? And so one of the things that we talk to people about, and a lot of times we include, is that, if someone's under the age of 25, we don't necessarily want to be writing them a big check or writing them or signing a deed. There's some really cool brain research to back that up about brain development that we can talk about later. But yeah, it really depends on what the deed says, and it may end up, instead of going to their beneficiaries, just go to their spouse. It may go to after their spouse, after their kids. It may go to the other people that are on that transfer on death deed. It really depends. And so we're always very careful about, is this really a transfer on death deed the way we want to go here, or do we want to have a trust or have a will that really spells that out? So great question. And Jenny, anything else you would add to that?
Yeah, just one thing is that, you mentioned it may go to some other people, but the route that may happen is through probate, which is the purpose. We're trying to avoid that. When we do transfer on death deeds, they're a good tool, but we want to be very clear about what they can and what the pitfalls are of that you laid out really well.
Well, thank you for answering that question. And thank you, Celeste, for the wonderful, thoughtful question. We also have some additional upcoming webinars that we'd like to just let you know about on our next slide here to keep an eye out for. So next Wednesday, August 5th, we have a great presentation scheduled with Lynn Peterson. He is the district director of the Farm Service Agency with Randy Clinkscales. We also have an upcoming symposium for healthcare workers in October. So please feel free to visit our website to register for these webinars and stay updated on additional events. It doesn't look like we have any more questions. So thank you so much for your attendance and participation today. And if there are no other questions, we'll go ahead and conclude our meeting. Please feel free to fill out that survey, call our phone number if you have any questions, visit our website to stay up to date on upcoming events. And thanks again, and please let us know if you'd like that free consultation and a book. So thank you, and have a great rest of your day, everyone.